you very much for inviting me and for this kind words of introduction. When I received the invitation to give this talk, I think it was just after the beginning of the war, February 24th, and I was contemplating at the time about the war, the consequences, the ramifications for international law, and I was really preoccupied with that. And when I received the invitation, I thought, well, here's another angle that probably we should be looking into. So proposed this topic, and it was accepted, and I went to work. And this is something, so today I'm going to share with you my thoughts, my initial thoughts about this, this very complicated topic, and unfortunately topical. What I'm going to suggest or to address are a number of questions, and maybe more in the Q&A if you like to hear more. First of all, question of jurisdiction, how to reconcile investment state dispute resolution, dispute settlement in the context of armed conflict. What questions arise in the context of jurisdiction and applicability of investment dispute settlement. Then preliminary concerns about the exercise of jurisdiction, whether the investor-state dispute settlement process is suitable always, or is the proper way to address questions of armed conflict and the consequences. Then a choice of law. We are here to, in a way, competing norms, competing set of norms, even competing philosophies about the regulation of disputes, and then what should be the outcome, how lawyers should address this kind of conflict of norms. And finally, the application of IHL or international humanitarian law the substantive matters, the extent to which IHL provides legal support for legal protection of investment for investment, the way the differences between the laws of war and the laws on investment, and also the relevant standard of review when arbitrators are supposed to apply the law to a particular context. Should they adopt their independent view of questions of military necessity, for example, or should they respect the decision-making by the commanders, even the commander in the theater of operation, as to the question of balancing, proportionality, necessity, and so forth. So let me turn to the first set of questions related to jurisdiction. So, first of all, a preliminary question. The question whether bilateral investment treaties are applicable in a situation of war. So we tend to distinguish between international armed conflict and non-international armed conflict. This is the jargon, legal jargon, that distinguishes between the rules that apply to an armed conflict between states and one that applies to the armed conflict within a state or between a state and non-state actors. There are some differences in the rules, although in recent years there's more many commonalities. But our beats remain applicable. So The short answer, the simplistic answer is, in principle, yes. So here are the draft articles on the effects of armed conflict on treaties from 2011, 3 draft articles that many scholars regard as reflecting customary international law. And this is encapsulated in Article 3 that says that the existence of an armed conflict does not ipso facto terminate or suspend the operation of treaties. And there's then a list of treaties that includes treaties that protect private property and treaties that provide for dispute resolution that are among those treaties that by default are regarded as continuing in operation despite the fact that there's an armed going on between the parties to the conflict. But then, as Article 5 suggests, ultimately it's a question of interpretation. So decision makers, arbitrators, parties should look into the treaty itself and what does it say, and maybe some treaties, some bilateral investment treaties, would provide for a different answer. So ultimately, it's a question to be determined at the outset, according to the Vienna Convention's rule of interpretation. This is a development. It is a transition in the way lawyers used to regard the applicability of treaties during warfare. If you go back to the Vienna Convention, so in 1969, we see in Article 73 that the question was open, and the parties wanted to leave that question open when they said that provision of the present convention shall not prejudge any question that may arise in regard to a treaty, including treaties from the outbreak of hostilities between states. So it was contentious at the time, back then, 1969, whether treaties continued in force despite the ending of hostilities. And that means that we are facing a transition from a bifurcated international law of peace and war. So in the past, there were 2 books. There was, remember the Oppenheim book? So there were treaties on the laws of peace and much weightier volume on the laws of war. So there are 2 steps, 2 different phases. And once state declared war, they would move from one legal regime to another. With the transformation from, the distinction between peace and war to a situation in which an armed conflict doesn't really change immediately the obligation of the parties, we have moved to a regime that is that can accommodate treaties regarding peace, treaties regarding war, the same way. And I highly recommend actually a doctoral dissertation from UCL here by Ira Reich-Lackman, The Protection of Foreign Investment in Armed Conflict. They have a chapter about this evolution of the law in this context, which I found illuminating. And obviously, there are 2 famous judgments of the ICJ, which actually assume that the commercial treaties between the French navigation and commerce continue in operation despite the armed conflict that they are engaging in. So I think this question is more or less settled. And now I want to move to a more, to explore different scenarios in which a bilateral investment treaty might become relevant during armed conflict. So obviously, the first situation is in which a party to a conflict seizes investment as enemy property or for any other security reasons. And if you take the ongoing conflict, the seizure by the Ukrainian government of a Russian bank after the invasion, so seizing a property as enemy property, right? And justifying that seizure on the basis of the laws of war or on the basis of general international law. So this is one occasion, and also when there's a non-international conflict, when a party causes harm to investment, or for example, destroying property that is held by the enemy, attacking, say, a factory that is owned by a foreign investor because there are enemy combatants hiding in that building, or destroying property that is located in a strategic location that is important for the army to protect itself or to advance, or using equipment for military purposes, seizing cars or SUVs owned by the foreign investor in order to push combatants to the battlefield, or not protecting, so harm caused by third parties that the government fails to protect. And that could also raise questions about the protection that the state is supposed to provide during, based on the investment treaty. More complicated questions arise in the context of occupation. So if the occupier causes harm to investors who are local citizens, these investors, or these are property owners who happen to have, say, a factory or any other investment, a hotel, in an area that used to be their own country, but now that country is occupied, or part of it is occupied. Have they become foreign investors? Has the property become invested in an investment covered by the bilateral investment treaty between the occupier and the occupied? So there's a number of arbitral decisions concerning the occupation of Crimea by Russia, claims by Ukrainians who claim to be now foreign investors. And the response is that the bilateral investment, a party to the investment treaty, is committed to protecting investments of the foreign citizen in its territory. Now, this is not the occupier's own territory because it's an occupied territory, but it is territory that is under its effective control. Right? Now, what's the difference between a territory that is its sovereign territory and a territory that is under effective control? There's a lot of difference, of course, but tribunals have come with the argument, actually bought the argument, that there's no difference from the perspective of the commitment to protect foreign investment. It doesn't matter whether you are exercising authority sovereign authority in your territory, or you exercise authority based on international law in an area that you occupy. Now, what happens if the investors are your own citizens? Let's assume that the Russian investors in Ukraine, when Crimea was Ukrainian, but Crimea legally is still Ukrainian, but it's controlled by Russia. Now the Russian citizens investing in an area that is now under Russian control, can they be regarded as foreign investors? There's no privity in terms of, there's no difference in terms of the nationality between the investors and the government that exercise the control. But even though you might argue that the bid itself is inapplicable, there's an argument that it's applicable by or through the laws of war, the law of occupation that requires the occupier to respect the laws in the country. So the occupier, and I'll come back to this in the second slide, so the occupier must protect or must respect the laws, and arguably the laws include the BAT. Right? So this is another scenario. Now the third question, I think is the most complicated, is whether one could say that an investment is protected not only during occupation, but also before the occupation, during hostilities. So let's assume an army attacks, an army shells a factory. There's no effective control, there are no soldiers controlling the factory. The army is bombarding the factory. Does this attack translate into exercising effective control? So if you ask the same question from the perspective of international human rights law, same question arose with respect to international human rights, and particularly European Convention of Human Rights. And the European Court gave all sorts of answers. It wasn't clear, ultimately. Ultimately, I think more recently, the court tended to say it doesn't apply. There is no effective control until you have boots on the ground. So the very attack does not translate legally to exercising effective control. But as I said, it's still unclear, and some people say unconvincing, so the argument is here. In other words, there may be room for an argument that a decision to share an investment is covered by the bilateral treaty. What comes out of it, it's a different question, but the question of applicability might be answered in a positive. Especially, I would say, if the balance of power between the two parties is obvious. So if there's a powerful army that can do whatever it wants, then might be regarded in control over the target. What about nationals of third states? Are they protected? Do they remain protected during a conflict between two parties? So, so here's the question. I'll give names. So there's a state B, we'll call it Ukraine. So Russia occupies parts of Ukraine. And there is an agreement between Russia and a third country, investment agreement. I think the same logic that stipulated that Russia is committed to protecting investment in the area of effective control would mean that the same treaty applies also to the area that Russia occupies. So in a way, when Russia progresses or captures more and more territory, it takes with it the bilateral investment treaties that it is party to, and remains committed to them vis-a-vis third parties. Now, what about stop here. Oh. Now, let's assume that now the occupier is being asked to be accountable for harms to an investor who is not an investor of the occupied country. So, for example, if the Russian occupying force in Crimea is being sued by investors from, say, Poland, and let's assume that there's a bilateral investment treaty between Ukraine and Poland, why should Russia be responsible for an infringement of a treaty to which it is not a party? How come? There's an agreement between Poland and Ukraine. Russia is an occupier. It is not a party to that conflict. But, here's the but, the laws of war, the laws of occupation stipulate, this is Article 43 of the Hague Regulations, that the occupier must respect, unless absolutely prevented, the laws in force in the country. Can we say that all bilateral investment treaties ratified by the sovereign government that is now ousted is part of the laws in force in the country? Well, you could say no, because bilateral investment treaties are not part of the laws in force in the country. We understand law to be the local law rather than international obligations. They have no immediate effect based on the dualist position, no immediate direct effect in the country. But the logic of Article 43 is that the occupier must respect and ensure public order and civil life. So must ensure stability, must conserve the legal regime in the country, and that includes the protection of investments. So it is international law, the law of occupation, that imposes on the occupier the international obligations of the occupied state. There's one possible exception And this is when the occupier, in violation of the laws of war, ratifies an agreement, a bilateral investment agreement that covers the occupied territory. When the occupier does not respect the obligation to conserve the legal framework in the occupied territory, when it does not recognize the occupied area as foreign, when it is illegally assumes sovereignty over that area, and there is an obligation, international obligation, not to recognize their claim of sovereignty. And in violation of this principle of basic principle of the law of occupation, when they operate as sovereign and sign treaties, that might be problematic, that might lead to the invalidity of the treaty that was signed. And here's an example, a recent example, when the EU General Court annulled the Council's decision to approve an agreement between the EU and Morocco, because the agreement included the occupied part of Western Sahara, which is not under international, it is not part of Morocco. And without consulting the people that is entitled to self-determination according to international law. And that was the reason why the court said it is illegal for the EU to disregard that principle of international. So new bids might not be regarded or should not be regarded as legally valid. But all the bids, they are part of the law of the land, and they arguably would be still valid. So this is a question of jurisdiction, and now a question of the appropriate forum. There may be reasons to decline jurisdiction or suspend the bid procedures or otherwise modify, maybe through limitations on the damages, taking into account the fact that this is an armed conflict, involves millions of people affected, and lots of people, lots of companies are entitled to be compensated. So what should be the proper forum for addressing mass claims for damages? There are concerns about the effective processing of mass claims, about the distributive considerations, those who would get compensation, those who would not get anything, and questions about the sustainability of the economy that needs to rebuild itself after the war. So there are macro considerations that might affect the exercise of jurisdiction. The point I want to make is that if you look at the perspective of the laws of war or IHL, under IHL, there is a clear preference for the principle of diplomatic protection. So individuals have no direct right to a remedy. This is an old principle that begins in the Hague Convention that requires parties that violated IHL to pay compensation. But the obligation is on the state parties, and that it does not translate to a right to remedy of the individuals who are affected. So even recently the ICJ in the advisory opinion concerning the Palestinian wall made the point that Israel has an obligation to compensate all natural legal persons having suffered, but the court was careful not to say that all natural legal persons have the right to remedy, right? Now, this reflects the idea that we need governments to be involved because there are so many claimants, and there has to be some kind of a compromise on the large scale, and governments should be the ones to make the necessary adjustments. Otherwise, it won't work. It is not realistic to believe that all victims would receive compensation if people would have directly enforceable right. In conflict marked by serious and widespread violation of international humanitarian law, victims are too numerous for such system to work. This is Emanuela Chiara-Gillard and John Duga, the special rapporteur of the ILC on diplomatic protection, says diplomatic protection potentially offers a more effective remedy in this context. Most states will treat a claim of diplomatic protection from another state more seriously than a complaint against its conduct to a human rights monitoring body. And here I recommend this article by Juras Rilic on this very question. Now, turning to the third, I hope the timing is okay. Turning to the third, so about half of the lecture is now behind us. In terms of accommodation, in terms of how to reconcile the two different regimes, there are two clashing philosophies, I would suggest. At least at the outset. Investment law, insulating investment from politics. We know all the different rules here for protection and security. Sometimes you have specific wartime protection articles, provisions. The idea of national treatment and most favored nation treatment, no expropriation without compensation, and fair and equitable treatment. And importantly, this applies also to state-owned enterprises. So they are part of the separation between politics and the economy. Very important part of the investment regime. Especially in countries in which there is no clear separation between politics and economy, in which state-owned enterprises are very much practically part of the establishment, part of the political institutions. This doesn't work or doesn't translate well to the laws of armed conflict, which begins with the Lieber Code, the very famous statement by Francis Lieber that the citizens or native of a hostile country is thus an enemy, as one of the constituents of the hostile state or nation, and as such is subjected to the hardships of the war. So the idea here is that the enemy, so the national of the enemy is an enemy, right? So Jewish refugees that came to England and happened to have German citizenship were interned as enemy citizens during World War II. And the typical way to address enemy citizens' property was through the trading with the enemy statutes, which meant that property of the enemy citizen was vested in the state. And the original owners hold nothing more than the expectation of getting the property back, an expectation that is subject to the arrangement made when peace is concluded. So if you were a German citizen during World War II and you had an investment in England, you had nothing but an expectation to get the property back if the governments agree to that after the war. This is the leading treatise of international law at the time. So how to reconcile this approach with the protection of foreign investment? So, specifically from the perspective of IHL, protecting property is subject to securing that the owner of the property is a private actor and the property is used for private use. Private ownership is protected under the laws of war in occupied territory only. That's important to note. The laws of war, the traditional laws of war, the Hague Regulation, the Geneva Convention, refer to protection of property in occupied territory. They say nothing about protection of property of the foreign citizen who is an enemy citizen located in the party to the conflict. And the Geneva Convention refers to the protection of protected persons' property. And protected persons is a legal term that refers to the citizens of the enemy. So the citizen of a third party, third country, will not be a protected person, and the Geneva Convention will not apply to them at all. It has to be private ownership, and it has to be used for private functions. Only if these two conditions are met, property in occupied territory will be protected, will have to be protected by the occupier. During hostilities, there's a different test for protecting property. This is the principle of distinction that stipulates that a party to the conflict must refrain from attacking targets that are not military targets. And military targets are defined by their function, whether by their nature, location, purpose, or use, they make an effective contribution to the military effort. Minutes. So, which means that state-owned enterprises may not be protected as they are protected by the laws of investment. So we have a conflict of norms, so to speak, and how to reconcile that. There are probably two different ways. One is to adopt a lex specialis approach. But then what would be the lex specialis? Would it be the laws of war? Would it be bilateral investment treaties? And the other way, which I think makes more sense, is to think about accommodating, trying to find middle ground. It's based on the assumption that states that ratify treaties believe that there's no, that they are not mutually exclusive, that there is some way to accommodate the differences. And this is actually reflected in the Vienna Convention, Article 31(3)(c), and the jurisprudence of the European Court with respect to the tension, possible tension between international humanitarian law and international human rights law. finally, very briefly, because I have only 4 minutes, is how to balance military necessity and property protection. So how to actually apply the laws of war and the laws of investment protection in specific contexts. Whether an attack on a factory was lawful under international humanitarian law, lawful as and the bilateral investment treaty. The extent to which decision makers, judges, arbitrators could or should kind of second guess the commander's decision. So as a commander, the commander thinks that they need to attack a certain factory because they think that there are combatants hiding in the territory. Or they think that they should attack a certain location and maybe there will be some collateral damage to civilian property. This is their view. Should arbitrators second guess and say, we think we have the discretion to say that the commander was wrong? Or should they recognize that their task is more secondary and give more authority to the commander on the ground? This is, I think, an important question, and this is how I started the whole exercise in my own thinking. And here, what's important, and I think fundamental distinction needs to be made between two types of decisions. There should be more strict or objective review of a decision when the decision is alleged to be a violation of a jus cogens norm or a war crime, an act of aggression, for example, wanton destruction of private property. And this is reflected in the ICJ's oil platform judgment, where they say, we don't buy the American argument that they were attacked. There was no case for self-defense. How come judges say that there's no case for self-defense? If you feel threatened, if you know, I mean, if under the circumstances, you think there's no way to wait because the attacker will hit you unless you strike first, then judges in some place would say, well, no, you were wrong. How come? So the answer might be, this is an act of, whether or not it's an act of aggression or a war crime, this is a fundamental question that judges may not give discretion to the commander on the ground. It's much more complicated. It's much more fundamental. A question that needs to be answered based on the clear test that the law provides, as opposed to more question where proportionality and balancing weigh in, where the reasonable military commander becomes the metaphor for providing more freedom for the commander on the ground to reflect on whether there was excessive harm to civilians, whether there were alternatives to a military attack. And here I rely on the words or the thoughts of Professor Enzo Canizzaro in his analysis of oil platforms. So to conclude, what I tried to give is a general roadmap raising a number of issues that arise in a conflict that involves also protection of foreign investments. There are more issues to address For example, for damages, should they change in relation to other claims that may arise when millions of people are affected and need also some protection and some remedies. I wanted to point for the idea of accommodation of the different norms, suggesting that there is much in common, but there are also tensions that need to be accommodated and to be addressed. And to suggest that there's yet a third branch of international law that might become relevant, which is international human rights law. But this is a matter for a different lecture. Thank you very much.